Thank you all for coming, logging in. I can see that a few of you, we've got, I can see your names here listed. I can't see your pretty faces, but um, I appreciate making time. And I think it's worthwhile. I know we're all busy these days, but just to take a moment to um, look at these sorts of things. Sometimes these things can sort of save a lot of grief in the future if you can sort of bed down certain issues. And really, it's all about risk management, these sorts of things. And this is hopefully will be a useful session to get a bit of a better idea on contractual terms and where your risks lies as businesses and contractors. If anyone has any difficulty hearing me, just unmute yourself and either type me. You probably can type something via Zoom, or you can just speak and tell me that you can't really hear me that well. Also, as Charlotte mentioned, there is I'm more than happy for you to raise any questions that you have. I'll be going through basically key areas of contracts and key terms that I think are the most important terms in the sorts of contracts that people in your industry would face, and frankly, lots of contractors in the construction industry face. And so if there's any queries that you have or anything you want me to clarify, I'm more than happy to do so. I've got my two esteemed colleagues here, Ben and Chelsea here sitting with me. We've got a reasonably large team here of lawyers who specialize in the construction industry, from the beginning front end type work, which is contract preparation, contract reviews. We also often get involved in mid-project type situations where it's either issuing notices or trying to resolve things like variation disputes in a project. Often these things can be resolved mid-project without lawyers, but in certain situations we get involved in that. And of course, a lot of our work is the back end dispute work, whether that's in the residential space or the commercial space or the civil space. Look, I do often do these sorts of talks to associations like World Australia, and I think it's very important to understand where your risks are in relation to subcontracts. Of course, there's sort of a view, I think, among some that you just sign whatever you get given, and as long as the price is right and you understand what the scope is, that you don't have to get too caught up in the wording of long contracts that get dumped on people's desk, and that you put the contract in the filing cabinet and never speak of it again. But certainly from my perspective, and I know from talking to lots of people within the industry, that that's not really a good idea. People, whilst relationships can start off quite informal and quite friendly and amicable, certainly as lawyers we see where that stops being the case, and people really revert back to what the actual strict wording of contracts is. And from as an example, we've recently been involved in a long-running dispute regarding the wording of latent condition clauses, and the specific wording of those sorts of clauses can be the difference in millions of dollars. So it's important to, before you've started the project, to sit down and making sure that what you're signing, that firstly you understand it, and secondly that you're comfortable with the risk profile. And if you're not comfortable with the risk profile, then in some situations you should be thinking, am I really willing to sign this contract? Is this a risk that I'm willing to take on? And you may say, well, look, there is a risk and I'm willing to take that on, but really that decision needs to be made with at least some level of understanding of what those risks are. Now, I'm not going to say that you need to run off and get a lawyer to help review subcontracts or contracts whenever you enter into them, but sometimes it can be a good idea. At the least, you will have this sort of material. You can get a copy of the slides from Charlotte afterwards, and at least, even if you're not inclined to get a lawyer involved, you can at least sort of review the contract with the aid of these sorts of this sort of material. And I'll try to sort of make it as straightforward as possible. The problem with subcontracts is, of course, they're very often very long and complicated and use legalistic language that can be hard to follow. But within that sort of mountain of wording, there are sort of key risks that I look for, and it'd be good if I can sort of help people in the industry to be able to really see where the risks lie. So, as I said, I'll go through this course. Through this, I say course. I do a course for construction managers at UniSA, so I've just come out of my 6-week lecturing thing, so I'm used to referring to things as courses, and I won't refer to you as my students, but I'll be going through what I think are the key clauses and the key issues to really look at and look for in relation when you are dumped with a big contract. So I'll just make sure I know what time it is so I get through it all. All right. First things first. Design obligations. Now, I shouldn't say this isn't in order of importance, because I think there are probably more. There are some. I tend to get, if I lose sleep about clauses, it's generally clauses about liquidated damages and things like that, but which I will get to. But so it's not in order of importance, but maybe in order of sort of where they may sit within the contractual considerations. And one of the first things to really understand is, and it might sound basic, but the extent to which you have design obligations. Now, to a certain extent, in the welding industry, you may it may be something that is less of an issue than, say, a contractor who is doing broader scopes of work and may have therefore broader design obligations. But it's super important to understand what your obligations are, because it will often dictate the form of contract that's being used. I have been acting for I was acting for a joinery contractor recently, and sorry, I was acting for a fire services contractor recently, and they were given a design and construct contract, and their job was to obviously install the fire services like sprinklers and smoke alarms and fire doors and that sort of thing. And they were given and the first thing I was given a design and construct subcontract to review, and I said, "Oh, is this a design? Are you doing design work as part of your scope?" And they said, "No, we're just doing the construct." I said, "Well, this is a design and construct, so it incorporates." So I wrote to the other side and I said, "Look, why is there a design and construct?" "Oh, we need to use it as a design and construct, but we're going to remove all the design elements from the contract." And I said, "Well, why do that? Just use the construct only version of the contract, which does exist as an Australian standard type contract." And they said, oh, we can't because of one reason or another. And it just became this convoluted process of trying to remove all the design elements from this design and construct contract. But it is important for a few different reasons. One, and I'll get to this potentially later, but when I talk to contractors around the place, I occasionally hear, I'll never sign a fitness for purpose clause. I'll never sign a fitness for purpose warranty. Insurers don't like it. They can be quite broad in their application. They can be used to sort of create liability where one might say, well, I actually did the work as it was meant to be. My general philosophy about that is if you are doing the design aspect of your scope, that fitness for purpose warranty is not unreasonable. If you're designing it and building it, well, what you do should be fit for the purpose upon which you were engaged to design and construct. But if you're just doing certain construction work, so in the welding game, if you're only fabricating certain things and you're given a design, you're given the particular drawings and the specification that sets out this is what we want from you as a fabrication business. You need to make sure that the contract is clear that I'm just constructing what I've been told to construct. If it's not fit for purpose because it's been designed in a flawed way, then I'm not on the hook. I'm not. There shouldn't be a fitness for purpose clause in this contract, because there should be a clause that says I will build to what I've been engaged to build, but there shouldn't be a clause that says that what I build will necessarily be fit for purpose, because it may be that the reason it's not fit for purpose is because of the design that you had no involvement in. So look out for design obligations, and look out for, I'm sure I'll touch upon this later, but watch out for fitness for purpose clauses. They're in all contracts almost. It's easy to put in, into a contract if I'm a builder or a principal or whoever it might be that engages a steel metal fabrication business or welders, or to stick in a fitness for purpose clause. But you got to think, is this fitness for purpose clause something that should be in this contract? And if it's not, explain to the other side why you think it should be removed. And one of the other points when I have the opportunity to talk to associations like this is, don't be too afraid of asking for changes. My experience talking to contractors, and whether it be metal fabricators or electricians or the scope of the broad array of contractors that are out there, is that I remember having gone to a Christmas thing last year and someone coming out to me and goes, oh, all those changes to the contract that you suggested we make, I'd asked for them all and we basically got them all without any fuss. I didn't lose the job. I got the changes I wanted. There's sometimes a perception is if I ask for too many changes, I will lose the job. It seems from my experience that that's rarely the case. And I think it creates a level of respect, I think, between the parties. If you sort of show that you're someone who knows how these contracts operate and ask for reasonable changes. For example, if there's no design element to your scope and you ask for the fitness for purpose clause to be removed, I think that's a perfectly reasonable thing. And I think you won't get everything you ask for. You might ask for 10 changes and you might get 5. And, it's better than not getting any changes at all. So, in my view, is the general approach in these things should be to have to actually sort of ask for certain changes if you think they should be made. All right. Warranties. Now, this really harkens back to the point I just previously made, is make sure your warranties are reasonable. So you'll see a section in most contracts that is a sort of a warranty section. And that's an important aspect of the contract. So you'll see this 40, you might have a 40-page document given to you and go, geez, I don't want to read all this. It's all a bit confusing, but one section to sort of zoom in on is there will be a little section normally called warranties, and that'll say that it'll usually say that you as the contractor agree that your works will tick certain boxes. It'll now you'll see certain warranties like that the works will be done with due care and diligence. Well, that's fine. You never take issue with something like that, because that's your obligation as a matter of law, regardless of what the contract says. Your base level warranty is going to be due care and diligence, that you've done the work with due care and diligence. And that really often covers the field. I mean, that's really often all anyone ever needs to provide. The consideration is really to the extent that the warranties go beyond that. And one consideration is that anything beyond due care and diligence may well be something that your insurer takes issue with. So, for example, fitness for purpose clauses are things that often insurers won't cover you on. Now, I don't know, if you don't do design work and you just do construction work, if you're just doing the welding, often you won't get insurance, is my understanding. Is you only really get insurance for design work. But there are always, as I understand it, interesting new insurance products come in, and insurers will find a way to avoid liability if they can, not denigrating insurers too much, but they won't pay out unless they have to. And one of the reasons they often don't pay out is if you've agreed to warranties that go beyond what's fair and reasonable. And one of them is, of course, potentially fitness for purpose clauses. So watch out for those. Now, I could spend hours talking about provisions relating to the timing of works, because counterintuitively, maybe to people within the industry, timing might, most people might think, well, the key issues are making sure I don't stuff the work up and I do the work with a reasonable level of care and it's not defective and I don't have to redo it. Yes, that's important. But one of the contractual risks that exist, I see that more as a building risk. That's going to be your risk, whatever. But from a contractual legal perspective, the sort of clauses that I spend a lot of time negotiating with the other side, because there is always room to negotiate. And the clauses are quite detailed in this respect, are the provisions relating to timing. So you've got normally start and finish dates. Now, you don't always have start and finish dates. Sometimes contracts don't have start and finish dates. You might get a purchase order or something that says, I need to do X, you need to do X, Y, and Z, and there's no great focus on when the works are to start or when the works are to finish. Now, in that case, as a matter of law, the law will determine that there is an end date. And what that end date is, it will be determined by the court based on what is reasonable. Now, what does that mean? It means whatever a judge who knows very little about the welding industry decides it should take to do welding work. So it's very unclear, grey area. So, but sometimes you might want, as a contractor, it might be best that you have no end date, because you can argue that it gives you room to argue. You might hear terms like the time is at large, which means they're sort of, it's impossible to really lock down on what an end date is, and that may work to your advantage. But by and large, there will be a finish date, and often when I'm contracting or reviewing a contract, there'll be a finish date. And one of the things I ask my client, I'll say, see, this is when they want your works to finish. Are you comfortable with that? And you should be more than comfortable. It shouldn't be a date that you think you might be able to reach if all things go well. It should be a date which has a little bit of float in it, as they say. And I'm not going to get into the weird and wonderful world of float. Who owns the float? I had a beer with a programmer late last year, and he was explaining to me about his views on who owns the float within a program. Um, um, and I really found it difficult to follow what he was telling me. But from my perspective, there needs to be a little bit of space in the program in case things go a little bit less well than planned, because we all know in the construction industry things never go exactly as planned, and there's always some delay, whether it's your operations manager quits, or Trump sticks tariffs on China and you can't get you have COVID, and I read about bird flu. I sometimes have to reinforce this to builders, is you can have a finish date, but we all know that there's going to be things that come up. So if you can factor that in earlier to the finish date, then you have to worry less about what I call the weird and wonderful world of extensions of time, which is really the part of the contract that I spend a lot of time thinking about, is extensions of time and when you are able to get them. So try to make your finish dates as achievable as reasonably possible. You'll obviously get pressure on the other side, because the other side want you to finish the works as soon as possible. So there's this tension that exists. So you'll never get things completely your own way, but at least turn your mind to these things. So extensions of time. There are standard wording in contracts that say that you get an extension of time if the reason for the delay is an act or omission by the head. Let's say you're engaged by a head contractor or whoever you're engaged by, but an act of omission by the head contractor or principal, whoever that may be, or other parties engaged by that party. So that can often be the superintendent. If you're in a project that's large enough to warrant a superintendent to be involved, if something's been caused by them, then you can claim the delay normally. Variations, of course, you can claim the extensions of time for. Weather. I've been seeing more contracts recently where weather isn't a reasonable delay. I sort of always thought as a bedrock principle, if it's raining and I can't go to work, you can't go on a site because it's there's a storm, that's a reasonable basis for an extension of time. Sometimes I see contracts where they're sort of like there's an estimated number of days you'll lose due to weather, and that's built into the contract finish date. Industrial relations issues, broadly, that's seen as covering if there's some sort of statewide strike, if the CMFEU or some other union or someone does some sort of statewide, countrywide type thing, you get an extension of time for that. Obviously not a common occurrence. Normally site-specific industrial issues don't get extensions. Now, that's sort of the bedrock, what you'll normally get. That's normally what, if you get a contract lobbed over to you and they say, sign this, I want you to do X number of, I want you to fabricate this, weld that. Often you'll get something with an EO extension of time entitlement that covers that. But have a think about whether there's more things that can be put on. I had a builder client who he knew that the framing was going to be something that was going to be more determinative by the principal, who had certain connections within the framing industry and was sort of pulling the strings in relation to the framing. So he thought, look, I haven't got as much control over that framing as I normally would. I'm going to build in an extension of time entitlement in relation to the supply of the framing. You might you might, as part of your scope, have to supply certain items, certain paneling, let's say, and you're getting the paneling from, let's say, Vietnam or overseas somewhere. And and you sort of feel like, look, if I get these people have told me I'm going to get these materials in 2 months, but if it's 4 months, I don't want to have to wear that 2 month delay. And I should say where these provisions are heading is the issue of liquidated damages is essentially to the extent that you are delaying, the works are delayed beyond the finish date and you cannot get an extension of time. Well, let's say that there's a finish date and then you're entitled to certain extensions of time that push the finish date back. Contracts will often say that for each day that the works are delayed beyond that extended time of finish, that you have to pay X number of dollars per day. So really the game here is to limit that risk. And I'll talk into how we can do that from the liquidated damages side of things. But of course, if you can get the finish date extended to the time when you actually do finish, then you of course remove all that risk. And even if there aren't LDs in a contract, that doesn't mean you don't have to pay delay damages if you delay the works. It just means that you revert back to the person who engaged you to actually prove their loss, which can sometimes be a difficult thing, which is why LDs are preferred by people who are engaging parties, because it locks in a particular figure. But that's why we're focusing so much on this, is because I'm trying to reduce the risk that at end of jobs, contractors are lumped with and it happens. I'm acting for a client who's just been dumped. The superintendent has just issued an LD certification of over $1 million. So these things do bite, and when they do, you wish you could have gone back and played around with some of these clauses a bit more. So this is your opportunity to try to think about, well, what might actually delay me for these works, and can I build that into the contract as entitling me to an extension of time? And so, look, I won't go through the sort of things that you guys will know as much as I will about what things might delay. Of course, if you subcontract certain work and they cause delays, and that's going to, but often, the principal or the builder engages you, they'll say you have to wear that risk. If you want to get some protection in relation to your subcontractors, you've got to build that into your contracts with your let's call them subcontractors. But anyway, you'll see there'll be a section that says you're entitled to extensions of time because X, Y, and Z. Look into that contract, part of the contract, and see if you can add anything more to broaden that as much as possible. That's just what I mentioned there. As I said, here is a couple delays caused by material and supply issues, changes of law. If the law changes and suddenly your scope changes because you have to comply with the law, that sometimes might be brought in. If that could create a variation that then allows an EOT, but obviously the gold standard of entitlements is anything beyond your reasonable control. If you can get that wording in a contract, then you're ahead of the game. But more times than not, the other side won't agree to that. The only people who ever get that included in their contracts are residential builders. In residential building contracts, anything beyond your reasonable control is an entitlement to an EOT. For everyone else in the construction industry, you all don't seem to quite be so lucky, and that people look at that as being far, far too broad. Now, I've just got to here, consider steps required to claim an extension of time. This is super important as well. Often you'll have contracts that say to claim an extension of time, you need to issue the extension of time claim within X number of days. And if you don't do it within that number of days, you can have clauses that said you are barred from claiming an extension of time. So it could be 3 days, 5 days from the time the delay event becomes something that you are aware of or should reasonably have been expected to be aware of. Try to broaden that out as much as possible. Try to expand timing requirements. There's a great clause in the AS 4000 head contract, clause 41.2, which says that there are no time bars in the contract. So if you do something not within the contractually required time, you don't lose the entitlement to make that claim. There is some sting in the tail with that clause, but it removes time bars. So time bars, have a look at when you are required to do things, particular extensions of time claims, and consider what it says if you don't hit that time. If it says that you are barred from making the claim, well, that's a serious issue that you need to factor in, because you don't want to be delayed, have a delay comes up that delays something for 6 months, that says that if you don't do an EOT claim in 3 days, you aren't entitled to claim an extension of time. So then you're delayed by 6 months, you can't claim the extension of time. And if your LDs are $5,000 a day, and you are delayed by 6 months, I'll let you do the maths. But I've got, on the new Women's and Children's Hospital, I've got contractors whose per day LD claims are many tens of thousands of dollars per day. So think about if they're delayed by 6 months, and they can't claim an extension of time claim, that's millions and millions of dollars. So these are issues that can be the difference between your business surviving and not surviving. So you need to treat them with a certain level of importance. Okay, we get to the great issue of LDs, which are, as I said, liquidated damages. They're per day or sometimes per week figures that you become liable for if your works are delayed. They've got to be reasonable estimates of the actual loss. So you might tell the other party, you've got to prove to me that this loss is what you will suffer if it's a delay. But of course, if there are to be LDs, your aim is to make them as low as possible. So that's the aim, and it often becomes a horse trading exercise. One of the important things that almost, if I can leave you all with one thing to keep in mind, is seek a cap on LD. So if you've got an LD liability of a certain number of thousands of dollars per day, it can get up high pretty quick. So it's very standard to include a cap on the LD. So you can say that my liability for LDs is capped at, say, 10% of the contract sum. So, if I can leave you with one thing, capping LDs, good idea. Of course, there's the flip side of the coin where you can claim damages if you are delayed. Obviously, the basis for you claiming delays is usually a bit harder than the other side claiming delays against you. But I sometimes feel like that's a forgotten aspect of contracts, is you can actually claim delays. If you're delayed, you can actually sometimes claim delay damages. Often you'll see in contracts that excluded, so you can't claim delay damages, but turn your mind to that. And in contracts, we're seeing bonus for early completion. I often see that removed from contracts, but consider whether you think that that's something that should be, because if you complete early, that could create a benefit for the other side. So it could be a win-win type situation. Now, another key issue that if you get a Word version of a contract to review or to sign, one good idea is to just do a Control F and just search the word indemnity or indemnic, just in case it's indemnity or indemnify or whatever it is, just so it comes up with every permutation of the word indemnity. Because I've been involved in matters where my client, the contractor, is one of certain number of people who are potentially liable, or let's say potentially at fault for a certain problem. So let's say that you're doing certain welding work and you're partly to blame because you did the works not quite as you should have, but maybe the drawings weren't particularly clear, that you were given and that you're not responsible for, and maybe the person who engaged you is partly at fault because they didn't give you certain clear instructions. Maybe the superintendent's a bit at fault. So maybe everyone's a little bit at fault. But if you've got an indemnity clause that says that you indemnify the party that engaged you for any problem that's caused or contributed to by your act or omission, then under the indemnity clause, you will be liable for 100% of the loss, even if you're only, say, you're only 10% at fault. Now, so this is part of the game of contractual drafting, is that the party engaging you, they want to lock in everyone to be 100% liable for the loss. They want to try to, so that it makes it easier for them. They don't have to worry so much about trying to get to the bottom of who's, is that person 20% liable? Is that person 5% liable? They're trying to lock in as much liability as they can. And what you've got to do as a contractor is try to say, no, look, liability should fall where it should fall based on a fair apportionment of fault. So if I'm liable, if I'm 10% at fault, I should be 10% liable. And so the way that people who engage you will try to avoid that and make you 100% liable for something that you are only 5% liable for are two things: indemnity clauses and proportionate liability exclusion clauses. So indemnity clauses will say you indemnify us for any loss. What I would do as a lawyer, I will try to build in proportionment into the indemnity clause. So it says, I will indemnify you to the proportion that my level of fault warrants. And of course, the party who is engaging the contractor will turn around and go, oh no, you've built in too much proportionality. What's the point of having indemnity clause if it's too proportional? So that becomes the tension, the battle. I'm trying to build in proportionality. They're trying to remove proportionality. They'll have a clause that says there is certain legislation that talks about proportionality, unsurprisingly referred to as the proportionate liability legislation. It's got a longer name than that, but it basically mandates as a matter of law this concept of proportionality of liability, so it's commensurate to your level of fault. And you'll see in contracts, ubiquitous in contracts where it says the proportionate liability legislation is excluded from this contract. Now, as a matter of law, without getting too technical, it's not clear in South Australia whether that's lawfully able to be done, but there is a risk it can be. So I always tend to push back and say, no, we don't want the proportionate liability legislation excluded. The other side always say, in my experience, we do want it excluded. And generally, my contractor clients are happy. Just go, I don't want to fight about it. I'm not super clear on what you're talking about. Let's just leave it in. And so part of my challenge is to explain these somewhat complicated concepts so that people do fight a bit harder to keep the proportionality in the contract. But as I said, you don't get everything you want, but I think you've got to seek a fair balance in the contractual risk. This is all, as I said at the beginning, trying to balance risk so that not all the risk is pushed down onto the contractors and the subcontractors and the subcontractors, trying to make sure that the risk is fairly balanced between the parties. And that's the process of the contract review, is to try to fight for that fair balance. And you only succeed as much as the other side will allow you to succeed. But if you don't think that there's a fair balance, you then can decide whether you want to progress with that contract. Those points are the ones I've just mentioned there, so I'll move on. Latent conditions, probably not as much as an issue for fabricators, metal fabricators and welders. latent condition clauses are, of course, when unknown issues arise, normally subsurface issues. So what is in the ground? That's why I say it's probably not overly important for you guys, but um, um, from my perspective, when because I act for a broad range of contractors, it's certainly something that I look at. And a lot of, if I'm working for electricians or fire services or or plumbers, there's often I'll I'll get comments. Oh, look, for my scope of works, this isn't really important. But look, the latent condition clauses are always finely balanced about what is a, if it's a latent condition that you do have protection on. So let's say a latent condition, something unknown in the soil or maybe in an existing building, you might have to do work in relation to an existing dwelling, or sorry, an existing building, I should say, whether it's an industrial building or a commercial building, and there's maybe some sort of unknown problem that arises that causes an extra 100,000, 200,000 worth of work that needs to get done, whether it's replacing soil or whether it's doing additional work in relation to an existing house, building that exists. The question is does that cost to do that extra 200,000 fall on you, or does it fall on the party that engaged you? And it really comes down often to the definition of what a latent condition is, and often it'll be a condition that someone should have reasonably anticipated in light of the material that was provided, and then it will come down to, well, what material that I was provided. But have a look at those clauses if there's something that you think could apply to you, to make sure that that whilst it may be uncommon for there to be a latent condition, when they do bite severely. So make sure that you think you're comfortable where that risk lies. So I'll work through some of these slides reasonably quickly, because what I've tried to do here is create a nice resource for you, whereby when you're going, almost like a checklist, when you're going through a contract, if you turn your mind to each of these slides as you're reviewing your contract, you'll be ahead of the game, in my view. So as much as anything, I'm really just identifying things for you to check off when you review it. But so I've tried to put in as many as I can without going over the top, of course. But I've got quite a few slides here of items, so I'll flick through them. Security, often you have to provide security, whether it's cash retention or a bank guarantee. Make sure that the terms are fair. The standard provisions are you get half back at PC and then half back at the end of the defects liability period. And usually it's your security is about 5% of the contract sum. So have a look at that. If you see anything unusual, push back. The great concept of rise and fall, almost a mythical concept, in the sense that banks and principals and head contractors normally run 100 miles from a rise and fall clause, which is, of course, where the price can actually increase if the cost of labor and materials increase after the contract is signed. I had a lot of people calling me in about 2021, after all the prices shot up through that sort of COVID stimulus type period. And it was, of course, too late. You can't retrospectively put a rise and fall clause into a contract after it's already been entered into. But there seemed, through that process, there seemed within the industry to be a little bit more understanding of rise and fall. I think in the GC21, at least for a period of time, the government put a rise and fall in their standard contracts. And if they start doing that, that can flow down into subcontracts. So have a consideration of that. Consider interest rates for late payments. Make that as high as possible. Of course, if it's too high, you can sometimes be invalid. But I sort of feel like 20%, you're starting to get into dangerous territory. But 15%, sort of, you could potentially get 10%. Reasonably standard. 5% I see quite common, but make sure you turn your mind to that. Variations, of course. You get all sorts of different wording as to variation clauses. Turn your mind to how it will work. Often people will want a little bit more locked in processes. So it'll be, you have to provide a quote. The quote needs to be accepted. That's often the dream, but the nature of construction projects is no matter what variation terms are included in a contract, they rarely seem to get followed. And it seems to be as I get given a bunch of emails that says, "Oh yeah, we've got a variation. Here's this bunch of emails," and it all becomes a bit of a mess. That often, if there's a superintendent involved, they work out a sort of a way to price it, and it can be sometimes disputes. But I don't have any specific way that I want variation clauses to be prepared, but make sure you understand them and make sure that they're something that you consider fair and reasonable. In a lot of the contracts that I review, almost all of them, there's this concept of the superintendent. Make sure you're comfortable with that process. In my view, they are often a value add to it. So you're not just dealing directly with the principal, you're hopefully dealing with someone who's independent. I know a lot of my clients, so if they hear me say that, laugh at me and say they're never independent. They're always pro principal or pro head contractor, whoever's the more powerful or the higher up in the contractual scheme, and that they're more problems than they create more problems than they fix. But the concept of a superintendent, I think, is a valid one, and you'll see that they're built into contracts. And consider whether you want to build one into a contract or not. I touched upon this earlier, just about time bars in the context of extension of time claims. But they're not just extension of time claims, they're latent condition claims, variation claims. You'll see a clause sometimes that says, if a superintendent tells you to do something and you think it's not classed as a variation, but you think it's a variation, that you've got 5 days to tell the superintendent that you think that what they're asking you to do is a variation. And if you don't tell them within that 5 days, you cannot claim it as a variation, but you still have to do the work. So that would be a bit of a kick in the teeth if you get told to do something that's a variation or clearly a variation. It's going to cost you another 100 grand, but you only tell the superintendent on day 6 of being told to do the work, not day 5. And there's a term that says you are time barred from claiming that as a variation. Therefore, you've got someone who's making some technical legal argument that you have to do the entirety of the work without claiming it as a variation. That would be a less than ideal outcome. So look at time bars, the timing of when you need to make claims. As I said, clause 41.2 in the AS 400 is the gold standard. If you can build something like that into contracts, which effectively remove time bars, it'll help me sleep at night. And it should give you a level of comfort as well. But it can be difficult because often if you're a contractor engaged by a head builder, they'll say, we can't remove the time bars because the government's put in time bars in the contracts, or the principals put in time bars in our contract. So we've got to put time bars into your contract. So my track record of removing time bars is checkered. Let's put it that way, because it's difficult because they want time bars. But it's then whatever benefit you can get, expanding the time frames, lessening the severity of the time bar. It's an effort that's, in my view, worth seeking to do. Limitation of liability. These clauses, I have a reasonable level of success at putting in that, and one might sort of scoff at sort of the benefit of it, but there's a million different ways that you can be found to be liable. And if you can get a term that simply says that your liability in relation to anything related to this contract is capped at 100% of the contract sum. Whilst that might say, well, that's not that good. I'm still liable up to whatever my contract sum is. That means that I could potentially be liable to an extent where I get no payment for a job. There is the odd job where the claim against the contractor is more than the contract sum. So you might be engaged 100 grand to do some work, and suddenly you find yourself there's a $200,000 claim against you, and you go, well, because it can sometimes be more, because it might cost more to fix the works than it costs to originally do the works. Or there could be claims of loss of profit, which I'll get to as well, where that can be excluded as well. But if you can get something that caps it, your total liability at 50 to 100%, better than nothing. And often accepted. This is the consequential loss. I have reasonably good levels of success of having a term included that says that neither party will claim loss of profit. This is, if you're building, if you're fabricating something, let's say it's a shop fit out or something for the defense industry. Well, the defense industry, less of a profit, but for a business, let's say, and they say, not only do I need to fix the error that you did with your welding work, but you've cost me 6 months of lost profit because I haven't been able to trade because of the thing that you were meant to have built for me wasn't built properly. So to limit your risk for that sort of claim, having something where you are released from loss of profit claims is actually quite useful. And I have quite good levels of success I've found of having a loss of profit is a form of consequential loss. So I've had quite good success of having clauses that remove consequential loss. Side deeds. This is more for head contractors. They're often told to enter into side deeds with the principal, basically where they agree to warrant directly to the principal. In your case, you could have that where you warrant effectively that your work will be done with due care and diligence. If there's a fitness for purpose clause, they'll stick that in the side deed, so that if the rationale for that is that if the person who's engaged you goes under, that the principal can claim against you directly in relation to the work. My only tip for that really is try to make sure that the obligations under the side deed are not more broad than under your subcontract. Defects liability period, standardly about 12 months. If there's anything funny in there that you sort of think looks odd, raise that. Dispute resolution. I tend to like to create some flexibility. So not locking into an arbitration process. Some people might say I'm a bit anti-arbitration processes, but I'm more I'm more pro options is what I'd say. So I tend to think loosening those options up is best, but often not a great deal of time spent on reworking the dispute resolution process. Termination clauses, try to make sure they're fair, not too one-sided. You often see sort of the ultimate one-sided termination clause, which is, of course, the termination for convenience clause. If they've got something like that in, make sure that if they do terminate for convenience, that you'll be paid for the work you've done, you'll be paid for the goods that you've ordered, and I reckon stick in something where you get paid a little bit extra because you've been put out by that, because you've effectively lost your profit that you would have otherwise earned. So I think have a little bit of pushing back and building a bit better compensation into the termination for convenience clauses is a good idea. So I'm running out of time here, so I'll work through insurance clauses. I rarely review those that closely, not because I'm lazy, but because I'm not an insurance broker. If you do want me to review an insurance provisions, I will, but I tend to think it's better that those are reviewed by your insurance broker. Make sure that you've got the insurance that the contract's going to require you to have is really the key. transfer of title. Sometimes I like to include terms that say that my goods will only what I provide to you will only be transferred to your ownership once you pay me. And to obtain this protection, we get into the weird and wonderful world of personal property securities register type issues, where you might have to register your security interest in the items. When I talk to contractors about this, usually their eyes glaze over and they're not that interested. But if anyone is interested in, they think that they've got a lot of items on site that aren't paid for, that sit on site for an extended period of time, I think it's important to turn your mind to this. Consider the terms about assignment and novation. Often as a contractor, you'll have a term that says that you can be assigned from the principal to the head contractor. Turn your mind to those clauses and make sure they're not unreasonable. So that's, when you go through a contract, turn your mind to at least those issues that I've just raised there as a bit of a checklist, I think you'll be ahead of the game as compared with most other contractors. You'll be even more ahead of the game if you get a lawyer to review. Lawyers generally will do what is called a high-level review, where they really just focus on key risks. And that's not too pricey. And if the contract's for a few $100,000, forking out a little bit of money for a lawyer to review key risks is often money well spent. But even if you don't do that, you've got now this, what I will call a checklist. And if you turn your mind to each of those clauses, you'll be limiting your risk. And that's what we're all trying to do as businesses. We're trying to lower our risk, and really that's what I'm trying to help contractors and subcontractor associations try to educate their members to do. This is not an exhaustive list, but I think I've tried to touch upon the key issues. They're my details there. Thank you. Now, if anyone does have any questions, this is a moment for me to for you to ask me. If not, you've got my email address there. You can email me anything, and I will clarify. I've thrown quite a bit of information at you today. If there's anything, a day later, you might go, oh, actually, I want to know a bit more about that. Flick me an email. I'm more than happy to chat about these things. So yeah, thank you.